have a case in India involving non-fungible tokens, which dealt with digital player cards. You know, our cricket is a very famous game, and a company signed a few cricketers and said we have the exclusive right to prepare their digital cards, which could be purchased by people. And some other company, without any authorization from the player, also came out with similar cards, and they said it was fair use. So that issue is pending before the division bench. The single judge has taken a view which the appellant says is a very constricted or a very narrow view with regard to personality rights. So, see, what we are finding is that it will be judge-made law to the extent that these issues will have to be dealt with. But this is also leading to a lot of, I would say, jurisdictional and jurisprudential conflicts. Because, see, one doesn't know where to sue. What should be the place of action? Because you are dealing with a frontier which has no boundaries. You know, you're online. The transaction could be happening anywhere in the world. So where would the suit be filed? No one has any clarity. And the downside of this will be that people will start chasing jurisdictions where they think where the plaintiff thinks he can get a favorable order. So there'll be a lot of forum shopping which will take place. And courts are not going to take a uniform, consistent view with regard to this technology or with regard to the rights which are involved. How will you deal with this issue? You know, because it's going to lead to a lot of conflict all over. Even with regard to personality rights, for instance, there is a wide difference of opinion in US and UK courts. They're taking divergent views. Now, this is a major issue which will have to be resolved. I really don't know how will we ensure that a uniform, consistent view is taken over a period of time. And it is not necessary that emerging technologies will fit neatly on the current legal structure as we have. You know, there is going to be a wide divergence of views. For instance, even take a small issue like standard essential patents of FRAND, which is in the old world. You find different courts have taken different views, and people will be going to different jurisdictions according to their convenience. So conflict of laws will be a major issue. The other thing is a company which is developing this technology, the brand owner as it were, he will not know which law applies because this does not have boundaries. So it is also got to do with ease of doing business. How will he do his business? He doesn't know the law, the principles on which he has to operate on. So there are various intrinsic issues, fundamental issues that are arising for consideration. And if the countries cannot agree on some basic harmonious principles, there is going to be a conflict of law.
Is this the end of territoriality?
Might be.
Looks like, because for me, boundaries have ceased to exist, and IPRs, which are considered territorial laws, their basic concept is in danger.